Representative Larson. Representative Sherwood. Excused. No. Representative Stith.
Here.
Representative Walters. Representative Swanitzer excused. Chairman Nicholas.
Referral property tax deferral programs. Come on up. So just give us a brief explanation of the bill and then walk us through the appropriation.
Thank you, Mr. Chairman. Thank you, members of the Appropriation Committee. I want to talk to you about House Bill 121. What I've done here is seek to amend the current statute on property tax deferral. The statute as it currently exists basically has the program within the counties. But the truth is, only 2 counties have ever operated under statute. Sheridan for just a little bit, about a number of years ago, and currently Teton County recently did implement it at a county level. The problem is that the other counties are not doing it. And I think probably the best evidence of why they're not is in the statute itself. It's part of the repealer on my amendment, but it says in section G of 3913-107 that the deferral option shall not be available to any county which has not adopted rules as required by subparagraph A of this paragraph, or which have received disapproval for the county program from the department. And I think that helps us understand why the counties have never used the deferral program. And so we have a situation where we have the statute and we have a deferral program, but effectively many people in Wyoming are cut off from that program because their counties have not been able to either have decided not to, or in the case of my county, just decided that promulgating rules and trying to run this program was beyond their capabilities and staffing. And so they haven't offered it, and it's not been advertised and it's not really known, but so we have a real inequity there. So one county right now offers deferral, but the rest of us don't have it because of this provision. So really what I've tried to do to make this relief more workable for the whole state is to pull it up into the Department of Revenue and have the department manage it, have them set standards and promulgate rules that apply statewide. So there's equality in that. And then to evaluate the affidavits, the applications are in form of affidavit according to the current statute. And, but have those then evaluated, and the Department of Revenue evaluate and issue those deferments. And then the appropriation we'll talk about in a moment is for the purpose of them then turning around and giving money to the counties for whatever they defer, and then the state would hold the tax lien, which was a part of the original statute. So that's what I'm doing, is pulling it up, and again we can talk about the policy of that if you would like, or we can move to the appropriations.
So I just have one question. We don't work. We're just going to talk about the money, but you're going to put the burden of the deferral on the state.
Correct. We're shifting that burden to the state to bear the burden of the deferral and to have the privilege of the lien.
Mr. Chairman, Representative Lawley, thank you so much. I'm just frankly not all that familiar with this program. How does it work right now? If my house is a part of the program that my house has to have some equity in it, or can I have negative equity in my house, like I owe $400,000 and my house is only worth $300,000? Can I still use this program now? And under your proposal, could I still do that? And the second question is, if it's a perpetual lien, is it contemplated that the Department of Revenue will be filing those tax liens with the relevant county clerk?
Mr. Chairman, thank you for that question, Representative Stith. That's a great question. And how it operates now, again, is the county handles all that, all the processes. But if the way the statute's written is that if you already have a lien on your property, or really even beyond a lien, any sort of contractual obligation that's of record against your property, like a contract for deed or something like that, then any of those parties would be required to be a co-signer. So in those kind of situations, likely they would not get them to co-sign or agree to that. So there, you know, that's kind of how that gets resolved. Now, the deferment might be helpful to know this, that the deferment is only up to half of the taxes for that year. I mean, you're eligible if you otherwise qualify for half of the tax for that year. And then once the tax deferments, because you can apply year after year, up to half for each year. Once they reach 1/2 of the fair market value of the property, no more deferments can be granted. So there are some protections and side roads that were already in the original statute. It's actually a really well-written statute. It's just not really practical when counties just decide that they can't run the program. So I hope that answered your question.
Mr. Chairman, just to follow up, I think you're saying that as a practical matter, I really need to own my house free and clear in order to be able to use this, because if I got a mortgage on it, my lender is never going to agree to that. Is that the bottom line?
Mr. Chairman, Representative Stiff, I would say practically speaking, you're correct, that who this really helps, in my view, is particularly older people or people who have owned their home a long time and they've paid it off, but particularly, again, older people that have lived there a long time and they don't want to move. And they want to stay in their home, but yet they're struggling with the taxes. So it's one of, again, a number of relief options. But I think, again, I want to stress this, it is currently completely unavailable to every county but Teton County. And to me, that's a problem in terms of access to this relief. And I don't think that was ever intended when the statute was first created.
Please.
So if the tax goes unpaid, we've deferred it, we've paid the county, counties receive their tax goes on unpaid. The process, I believe now, is the assets are sold, and you probably understand this better than I. Assets are sold, that's a county function, sheriff sale type thing. Now the state's holding that asset. Who's responsible to implement, do that sale and do that? Is that still go back through the county? If so, does the county come back and say, listen, this isn't our issue? You know, state, how does that all work?
Mr. Chairman, Representative Larson, again, another great question. So when the state holds the tax lien, the statute has a couple of ways that are expected that would ultimately be satisfied. Abandonment of the property, for example, any transfer of the property, sale, death on deed type transfer, those things would come under as that would trigger the payment of the tax lien in order for those transactions to occur. And there is provision in the original statute for the department to declare the tax lien due. And then that's when you get into moving into the enforcement of the lien. But they would hold that lien position, and which is a superior position as a tax lien. And they would hold that position and they would enforce the lien according to the normal process of enforcing a tax lien, which I believe, I'm not an expert in this area, but I believe it works differently under the law than the enforcement of a county for unpaid taxes. It's a whole different system and process.
Okay. Thank you.
Further questions? And tell us a little bit about the money.
Okay, thank you, Mr. Chairman. We're asking for $200,000 to completely go towards a fund to pay the satisfying of the counties for any deferments that are granted, each one to that county. And that's what we're asking for in this bill. But let me tell you about how it's structured, because I want to be completely open about it, is that I've structured it in such a way because we're asking the Department of Revenue to do something. They do things similar to this, but this is a little bit different. And so we designed the statute to give them a chance to promulgate rules and determine how they would do this, how they might need to make some changes in their IT work things and to do this properly. And then they're going to report back in the interim the rules they promulgated, because there's some issues about with a limited amount of money, because the statute does require that they only give out deferments to the extent they have funding. They can't over defer. And so how would they make those decisions? How would they choose if there was a lot of applications? And they're going to come back to really the revenue committee and report on that in the interim. And that there may be, I will not be surprised if they would come back with some requests related to that in terms of what it may cost, because it's kind of hard to really know right now. So, but the appropriation in this bill is $200,000 for those tax deferments. There's also a provision in the bill that I asked for that when the deferments are satisfied, that money would be, the special account would be created and the department would put the money they receive when those liens are paid off into a special account that would become an account where eventually we don't have to ask for appropriations. It kind of funds itself. We start it and it funds itself because this does sort of anticipate then an annual appropriation of this amount. So,
Okay, and so it's 200,000 is kind of swag to get the thing up and running.
yes.
Okay, any further questions? Any public comment? Seeing none, we'll close public comment. Go ahead.
Representative, when you brought this, when the agency brought this request, this is to be paid to cover the cost of the deferment. Was there any additional administrative costs that was going to impact the department?
Chairman Nicholas, Representative Larson, yes, that's part of what I was describing earlier about that we don't know what those are. So in the interim, they will report to revenue how they're going to administer the program, rules they're going to promulgate, and there can be some discussions about that.
Okay.
And then I expect that you will likely, I'm not a good predictor of anything, but I would expect that you would receive a request from the department.
I apologize, I missed that.
Go ahead. Representative.
New technologies. Thank you, Mr. Chairman. So I just want to clarify my understanding of, right now, if you can't pay your taxes, you have a process where they're auctioned off. And someone can buy them for a period. I think you have up to 5 years. I'd just like to clarify how this concept through the department interfaces with that at the local level, because someone already can defer their taxes for 5 years. They pay it back. There's an interest rate. I'm not sure what it is. Go ahead.
Chairman Nicholas. Representative Henderson, again, great question. That system operates independent, and that system is triggered when the tax goes unpaid. This is a relief where someone says, I don't want to not pay my taxes. I don't want it to be in the record that I'm not paying them, but I can't pay them. What are some other options? So you're kind of put on two tracks at that point. So if you choose to take affirmative steps to get a deferment, then you're under the deferment program and you end up with a lien that the state would hold under my amendment to the statute. The state would hold that lien and then it would be satisfied when, again, under the provisions I already stated. What you're talking about is the program at the county level when someone does not pay their taxes, and you are correct. There is in effect a 5-year period. Many people don't know about that. And also many people don't want to go that route because there can be stigmas. There can be stigmas with tax liens too. We can talk about that too if you want, so it's just a different system. And this pulls you out of it because what triggers that is the non-payment. The deferment is in effect kind of you're getting a deferment, so it doesn't put you in the you didn't pay category. I hope that makes sense.
Okay, any further questions? Okay, we have the recommendation on the bill. Move to pass, represented by Representative Walters, second by Representative Stiff. Discussion? Okay, roll call, please.
Representative Henderson.
Aye.
Representative Larson.
Aye.
Representative Sherwood voted aye via proxy vote. Representative Stiff.
Aye.
Representative Walters.
Aye.
Representative Swanitzer voted aye via proxy vote. Chairman Nicholas.
Aye. Okay, thank you.
Thank you.
See you next time. Okay, next, let's jump to House Bill 89, which we've already been discussing. And on your, we just passed out a substitute bill. And this was done at my request because if you may recall, the original bill had the justifications and explanation and findings in the back of the bill. And I said, no, let's not do that, do it that way. And so now they're in the front, but come on up and kind of refresh us a little bit about what this bill does and what it's for.
Mr. Chairman,
Go ahead.
a question to your comment about where the findings are located. Did you determine where they're located? Depends on if they're going session law or into the green books? Is that why you made the change?
Well, yeah, and frankly, I want this to be in the green books. I don't want it in the back. Yeah. That, plus when people read the bill, they need to understand what we're doing.
Not against it. I'm just
Yeah.
wanting to make sure we accomplish.
Yeah.
That I was correct, that it needs to be in the front to be in the green books.
That's correct.
Okay.
Okay, Patrick? Don?
Mr. Chairman, thank you. I'm Dawn Williams, Deputy State Treasurer. Yesterday, I think it was yesterday, that when we were here the last time, you asked us to prepare some talking points for you for the bill. And then you also asked us to prepare a walkthrough of the bill. And we sent those to all of the members of the committee. The walkthrough just takes you through the bill by page. However, we're not aware of the substitute bill that you just mentioned. So this may be moved now.
Yeah, it just changes the page number.
Okay. So essentially, the bill is appropriating funds to these reserve accounts that Patrick will talk about. It gave you the page references, the amounts to be deposited to bring those accounts to a 5 times spending level, and then change the percentages before the tips to the corpus until those spending levels were reached at 7 times. You asked a question yesterday about the loan loss reserve account, and we added a little more, we had some notes about that, and Katie prepared some historical information as well about utilization of that account. It was only created in 2018, so it wasn't actually utilized until 2021 to the tune of $6 million, just over $6 million. And then last year, just $114,000. What the bill does is to remove the automatic appropriation for the loan loss from the reserve account. And so it removes the automatic provision, requiring then the agency to come to you, to the legislature, to inform you of the loan loss and let the legislature first be aware of the situation that exists, and then determine where that appropriation for to make the permanent fund whole would come from. So then the bill, so it explains that for all of the permanent accounts, and then at the end of the bill is the actual appropriation of the funds. So that's the walkthrough of that. And then I'll let Patrick talk to you about his talking points that he prepared about our goals and why this is why we present this IT.
Thank you, Don. Go ahead, Patrick.
Mr. Chairman, members of the committee, my name is Patrick Fleming. I'm CIO for the Treasurer's Office. So on the one-page talking points, I kind of wanted to condense it down into some of the things that we were talking about and what's the need. And, first and foremost, what we're trying to do is maximize the returns here while simplifying our process. But I think it would help if I took a step back and just really briefly just talk about why we're here and what happened. So at the time when we did the spending policies and the money that we had, if you think about it, but back in the 80s, 10-year treasuries were yielding 15.5%. And so the fund was only invested in bonds. It wasn't until 1996 that we were allowed to invest into 25% of equities. And now, well, that was when the rules in the issues that surfaced were done because there wasn't a need for it. But now, with rates so much lower and the amount of our allocations towards bonds, so for instance, in the permanent mill trust fund, we only have 12% of bonds and core fixed income that are 10-year treasuries are yielding 3.5%. So if you look at it and you say, well, the change of the portfolio, we have sent so many more investments now that don't have a yield. Private equity doesn't kick off any income, and yet it could have a 500% return. So that's really the gist of where we are. And so we're trying to say, okay, what could we do to do it differently? And that's the one where we get to the constitutional amendment, what we talked about, the problem with interest income, dividends, and realized capital gains. So that creates a problem because many of these assets that we have do not kick off income. Then we look at how are we going to be able to increase the return to the state? So the biggest part of it is if we can take these funds and put them into a return like we do in the permanent mineral trust, which has the highest perceived total rate of return. But to be able to do so, we need to increase our reserve accounts because the reserve accounts are too small in relation to what potentially the spend could be. Right now, they're 1.5 times. And what we're arguing is saying to be able to have that same type of asset allocation, we need at least a 5-time reserve account. And so that's what we're talking about. Now, when we go back and we look at it and say, well, 5 years ago, if we would have been able to have all of these funds into a total rate of return and also the reserve accounts, which are only 1.5 times, so they have to be in cash. If we could also put those in the same type of return, we would have earned $513 million more in income over that period, a little over $100 million a year. So there's many different things. People have different views on how we should do this. And all I'm presenting to you, the ways that we look at could be the highest return back to the state. And that's over the last 5-year period. If you want to change and say 10, 20, or what have you, it really doesn't matter because the premise being that a well-diversified total rate of return fund will outperform cash and low duration securities. And so that's really the gist of what we're talking about on what we're trying to do there in the different funds and why.
Mr. Chairman,
Please go ahead.
Mr. Fleming, if you can help me here, and this is the same question I came back to a couple of days ago, or maybe it was yesterday. So it seems to me there's a slight disconnect in the language, and frankly, I'm just worried about, in part, about a judge getting confused about what this means. So on page 4, we say that our purpose, so page 4, lines 7 through 9, through 10, I guess, says that our purpose is to ensure that each permanent fund reserve account is funded to at least 5 times its annual spending obligations. A transfer of funds to each reserve account is necessary. That's plain enough. When we get to actually implementing it, however, on page 9, for the permanent mineral trust fund reserve account, it's on line 13, it's less than that, right? And so by my calculation, and I understand the phrasing is slightly different because on page 9, it's 245% of the spending policy amount, which is different than page 4's spending policy obligations, because the spending policy obligation is 3.75, the spending policy amount is 5.0%, if my understanding. Okay, so to get to, if you fully funded the 5 times 3.75, that's 18, whereas the 2.45 of 5% is about 12. So there's a difference. Okay. And I think your explanation yesterday or the day before, was that you're assuming that even in a bad year, the permanent mineral trust fund will throw off something. Okay. And I think 2%. So you've actually calculated this so that we're getting a multiple, not of the 3.75% guarantee, but a multiple of the 1.75%, which is your calculated difference between the 3.75 guarantee and the 2% that you believe we're going to get no matter what. So question is, 1, am I understanding that correctly? And 2, do you have any suggestions how we word this so either we or someone later looking at this doesn't get confused about what we're really doing? Because I think there's an implied, we don't care about the first 2%. Is what it seems to be, but it doesn't say it anywhere.
Mr. Chairman, Representative Stiff, I'll answer as far as the numbers are concerned and what we look at, the wording on the bill. That's above my pay grade. I'll allow the experts to comment on what the best wording is, but you're absolutely right. So let's just talk about the two different funds, common school, which has a mandatory 5%, and the PMTF, which is the 3.75. So when we look at how much money, additional money will be needed, so each one of those reserve accounts have different valuations. And so when you look at it, we went back, Don Richards and I, we looked at historically, what is the lowest amount of return that we would anticipate with the portfolio that we have, and it's approximately 2%. So we're saying, okay, base case is 2% that we need. And then the additional amount would then be 3%, obviously, for the common school, and then the 1.75 for the PMTF. And that was the difference as far as the monetary component.
Mr. Chairman, just to follow up. Going back not to the common school fund, but to the permanent mineral trust fund reserve account on page 9, it seems that if the way you're calculating this is to fund the 1.75% differential, and you're saying, hey, no matter what happens, we'll get 2%, then really it's not a 5 times, it's actually a 7 times by the numbers, I think. This 245% number is actually a 7 times the 1.75%, which is good. That's great. It's just we've got this disconnect between we're making this assumption about the first 2% and we're funding it at 7% of the difference. But our preamble, we're saying we're doing it at 5 times. And so I'm just having trouble with the arithmetic.
But while we're in that conversation, I always thought it, as it was presented, and Patrick can clear this up, that we were going to put in 5 times and then not tip before it reached 7 times, which is what I thought. That's what this done on page 9.
So essentially what you're saying, Representative Stiff, is perhaps we need to be more descriptive. And that makes sense. So why don't you draft something?
Mr. Chairman, I'll make the attempt.
Okay. Representative Henderson.
Thank you, Mr. Chairman, and I hope I don't risk the possibility of helping Representative Stiff. My question goes to the spending policy amount. And just to clarify my understanding, please, on which I have none, but who controls that in between sessions or in between these up? Sorry. Okay.
Mr. Chairman, Representative Henderson, you control the spending policy amount, the legislature, and just historical wise, it was as high as 8%, I believe, and that was when interest rates were above 8%. So it made all the logical sense in the world. And I think at one point we got down to 4.75. We were going to 4.5, but then it bounced back up to the 5%. And that was the one where Representative Harshman said that was the second biggest mistake in his life when he allowed that to happen.
Okay. Any questions for Patrick? Any public comment? Any public comment on the bill? I think we already took it once. Any more public comment? Seeing none, we'll close public comment. We have a motion on the bill. Moved by Representative Walters, second by Representative Henderson. Discussion on the bill. So other than we want to, let's look at your language and we can bring it as a floor amendment, because actually by bringing the amendment, well, that'll help us describe the issue.
Sure. And Mr. Chairman, I fully support the bill. I think this is a great idea. It's a big step forward.
So what we could do is say the recommendation from the experts was a minimum of 5%, but 7% would be better. Better preserves it under extreme market conditions over 3 to 5 years.
And so this language puts in the minimum 5% and allows it to go to the 7%.
To get to 7. So I think that's how we catch it.
Mr. Chairman,
Go ahead.
I would move to use substitute X as an amendment for our bill, because I think we have to move that.
I think
as
that's
an
correct.
amendment.
All those in favor say aye.
Aye.
Those opposed, that motion carries. Okay, further discussion on the bill.
Question.
So, all right, we can discuss how we're gonna move this. and when, after we get this thing set up on get it on the docket. So question being called, roll call please.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood voted aye via proxy vote. Representative Stith.
Aye.
Representative Walters. Representative Swanitzer, aye via proxy vote. Chairman Nicholas.
Aye. Okay, thank you very much, appreciate it.
Thank you.
Next, this is. Yep. Which is number what? 264. 264. Come on up, John, have a seat.
Sweetwater Boys.
Yeah. Oh, fine. Please proceed.
Chairman Nicholas, members of the Appropriation Committee, thank you for the opportunity to visit with you today as with respect, more importantly, to House Bill 264, mining mural. My goal with this bill is really to formally recognize within the House chambers a mural that depicts, appreciates, and recognizes mining in Wyoming. We won't likely know that mining actually began in this state in 1843 with the Fremont Expedition. So when I view, as I sit today, as in the House, when I view the four true murals in the chamber, sadly, I think we're missing an incredible important part of our history and our heritage. Recognizing that representing all minerals, whether it be coal, soda ash, et cetera, that are mined in Wyoming is a very, very tall order. I feel that we can come pretty close to a mural that represents this rich history in the same motif as Mr. True did in the early 1900s. I've distributed two examples which I found to really demonstrate to some degree the idea. It's obvious that mining has a rich heritage in Wyoming, and it is without question mining has and is a direct contribution to educating our children, offsets our income tax issues, provides for the permanent Wyoming Mineral Trust Fund, and more importantly, promotes solvency in our budget and remains and promotes our economy's engine of prosperity. I think it's time that we take this opportunity and utilize money that mining has generated in this state since 1843 and appropriate funds for a mural recognizing our great mining heritage, our communities it impacts, and for the thousands of miners past, present, and future. With that, I ask for your favorable consideration is this bill in front of you, and I stand by for any questions.
Questions?
Mr. Chairman, Representative Conrad, can you tell me a little bit about the sample graphic here that we've been given? I don't know that would be exactly what the mural might look like, but one thing I really like about it is its focus on water, and it graphically illustrates how the Bitter Creek project would be a first priority eligibility project for AML funding. So thank you.
Chairman Nicholas, Representative Stith, that was the intent specifically. To your question specifically as well, that was just due to some, or more importantly, based on some searches on the internet. But obviously, Mr. True has passed on since he built those murals around 1917. So I was just trying to find something that articulated visually the idea of a motif that was respect to the, obviously the floor and the ceiling and the respective murals themselves.
So, you know, the primary issue that I have with this bill is subsection C, and who the selection process is and have it come from management council. I mean, that it turns it into more of a crapshoot, frankly. So, you mind if we tinker with that language a little bit?
Yes, Chairman Nicholas, that's a great question and point. In visiting with the LSO, we wanted to provide some oversight, specifically as it related to not only the appropriations, but more importantly, the motif and the delivery. So within that discussion with them, they suggested, which I did agree with, that those members of the management council would represent, obviously part of that being the Senate and also part of the House, but to provide at least some oversight so you didn't have one individual or other individuals driving, for lack of a better word, a specific idea or painting. So I'm amenable to change that however the committee finds suitable.
Good. I mean, so, we've been involved in different types of projects. We currently have a committee. It's made up of two members of the House, 2 members of the Senate. And it's called the Capital Wayfinding Committee. And for example, the furniture that are out in the hallways, we basically picked that furniture, ordered it, and we're doing various other components to it. This is a house project, but the other thing we might want to consider is if we're going to do a mural on the house side, are the Senate going to want something as well? And so we ought to approach that issue with our Senate leaders. And my point about management council is they might, I think we want, my suggestion will be that the speaker will pick 3 folks. And he can pick himself or he can pick a member of management council. But basically I think it's important to have people that have interest in art, the ability to have, to make this mural so it basically is the same type of mural as the ones that are there, so that they have to, and there's just some components to it that I think you want to be more selective about who's on that committee, is my point. Go ahead.
Your point's well taken, Mr. Chairman, and so if we amend that, can we just make sure that it says Representative Larson will not be on this committee?
Well, I'd like to amend it so I get it selected on the committee, or you, but that's just my suggestion.
No, Mr. Chairman, I think it's a wonderful suggestion, one which I embrace specifically. And I will share with you that I'd be honored to be a part of this. To go back to your earlier question as it relates to the Senate, I don't know if anyone's actually noticed. I did, obviously in preparation for today's testimony. On the Senate side, the murals, again, there's a number of them. One is the Indian Chief Cheyenne, a Frontier Cavalry officer, a Pony Express rider, and railroad builders and surveyors. That's what the Senate has.
And say that again, they want an Indian one.
I'm sorry, Mr. Chairman, Representative Larson, they have a number of murals. The first one being the Indian Chief Cheyenne. The second one is a Frontier Cavalry officer. The third one is the Pony Express rider. And the fourth one is a railroad builder and surveyor. The house, if you'd likely probably have noticed, are entitled Cattlemen, Trappers, Homesteaders, and Stagecoach. And I think it's a point in time to denote that as you look at the speaker's chair, there are 2 blank murals or 2 available spaces that I would promote to obviously choose one of those, whatever direction or side be there. But thank you.
Yeah, and the committee would basically pick the location,
Yes.
and the size, and frankly, if we do one, we probably need to do another one.
Sure. And
So they match. I mean, so that you have symmetry in the building. How did you come up with the dollar amount?
Chairman Nichols, thank you for the question. And just to briefly answer your earlier question, one of the areas that Representative Zawanister was concerned about is there other areas out there, would someone else want to put something there, whether it was oil and gas or some other reason, and I respect that and agree with him wholeheartedly. Mr. Chairman, respective to your question, the dollar amount was chosen based on consultation with the LSO, the Arts Council, et cetera, trying to get a value, not a swag, but as we say, a very good engineering estimate as it relates to the cost. I will admit that I chose the wrong profession as it relates to the $525,000 we're asking for, but that was done through the vetting of the LSO with others to determine how to make it or ensure that it is professional, it abides by the era that we're looking for, and does not detract from the, for lack of a better word, the sacredness of the House chambers. But that was a value that was given to me as an estimate. And I come before you to share with you, I think it's better to, with a budget so that I don't come back and ask for forgiveness later.
So just to provide another example, the Four Sisters out here, that was part of the capital working group. And then we had a subcommittee of that group. But then, the proposal went out nationally, basically. And I think we interviewed about 7 or 8 different sculptors and designs, and then eventually weeded it down to the folks that did the work. And we had a budget on that, but one of the issues that we always have is as soon as you put a price tag on something, that becomes the price tag to the artist. And so sometimes we try to couch it in a way that that number is more discreet.
Yeah, Chairman Nichols, that's a fair point. This was really put together as a not to exceed value. And within that cost obviously contains another components, a selection committee, et cetera. And I will share with you, part of the metrics that I insisted upon with the LSO was to ensure that we had a project timeline, a definitive timeline, such that we can capture the cost, understand the cost, and come back to you as a committee to truly articulate what that specific budget was and how we're going to maintain that budget.
Okay. Well, I think that's a great idea. I mean, we have talked to that committee and the Wayfinding committee have talked about updating those locations and on the floors.
Thank you.
So this is. Go
Mr.
ahead.
Chairman, one final question on the proposed funding amount. Other than say a phone call, is there any more formal estimate? I mean, this just seems like a lot of money for one picture.
You bite your tongue.
Chairman Nichols taking advantage of the bit in her bited tongue. I did not hear Representative this last component.
Mr. Chairman, can we do it for cheaper? I guess if we cut the money in half, would that kill this project or?
Particularly if we do two. So it would go out to bid. And so I think up to is not to exceed.
Yeah, Chairman Nicholas, thank you. Representative Stith, my concern is that if we reduce the cost, being fully transparent, I'm worried about the quality of who we might grab. Obviously, as you know, in the business, generally the low cost contractor gets, but sometimes the quality doesn't match. And my concern is that we devalue, for lack of a better word, aesthetically, that sacredness, as I shared with you earlier, that we are trying to uphold. So that's likely not an answer, but I would strongly encourage the 500,000.
Okay, public comment. Any public comment? Please come on up.
Sorry.
Thank you, Mr. Chairman. I didn't plan to comment on this bill, but in listening, I stand in support of it. I will say that I have in my few weeks sitting in the House chambers, it did occur to me that there were two empty panels there in the front of the House. And I do think they are there for our inspiration, all the images. And I would just add that one idea that certainly occurred to me and is that we could both celebrate the wealth that the state has enjoyed from its natural resources, both underground and on the ground, and perhaps a set of matched paintings that celebrate mining as well as our natural resources that are above the ground would be appropriate. Thank you.
Okay, any other public comment? Come on up.
Mr. Chairman, members of the committee, my name is Pat Joyce. I'm the Deputy Director of the Wyoming Mining Association. Of course, we support this bill. So just you'd indulge me for one moment. I'd like to speak on behalf of all the members of the Wyoming Mining Association and the Mining Associates of Wyoming. Wyoming enjoys the true riches, obviously. Okay. Of several minerals. One, of course, is bentonite. We call it the clay of the thousand uses or the miracle mud. Wyoming owns over 75% of the world's reserves, with an estimated 1.3 to 2.1 billion tons left to be extracted. We've mined bentonite in Wyoming for over 125 years. Trona, in our southwest corner in Sweetwater County. We have over 1,100 square miles of trona beds that lie below the surface in Sweetwater County. We're holding an estimated 200 billion tons or 90% of the nation's soda ash. And trona is Wyoming's largest single export. We export over 60% of the year, 60% of a year's production is exported out of Wyoming. Uranium, first used by the Romans in 79 AD used to dye glass and ceramic as a beautiful golden color. Today, we use it to generate electrical power, and who knows tomorrow. Coal, what Wyoming is best known for in the mining world. Wyoming is home to the largest coal reserve in the United States. The first coal record of deposit in Wyoming was located in 1843, as was referenced by Representative Conrad. By the second Fremont expedition, Lieutenant John C. Fremont, guided by Kit Carson, while exploring routes to the Oregon coast, were the first to find this. 60 years later, the area of Fremont's discovery became the site of the coal camp of Cumberland, south of Kimmerer, in what is now Lincoln County. The Reynolds expedition of 1859, 16 years after Fremont, recorded the second known discovery of coal in the state in the Powder River Basin, the location of the most prolific coal fields in the nation today. So it's safe to say that mining has earned its place of recognition in the history books of our great state of Wyoming, and today remains vibrant and critical to our state's economy. For over a century, mining has gilded the coffers of the Wyoming government to serve her people in a stable and substantial manner. Today, House Bill 264 proposes to recognize the longstanding contributions made to the state of Wyoming's culture, her people, her educational institutions, her infrastructure, as well as high-paying jobs and revenue delivered without fail to the Wyoming operating budgets by mining. Today, the 31 operating mine members of the Wyoming Mining Association and 120 member companies of the Mining Associates of Wyoming, who together represent over 26,000 proud working citizens of Wyoming, support the passage of House Bill 264 and look forward to the day when they can walk into the Capitol and point to that which represents their way of life in Wyoming. Thank you, Mr. Chairman.
Okay, thank you very much. Any questions? Representative Henderson.
Mr. Chairman, I apologize for the interruption. I'm so excited about this. I had a couple of questions. I thank you, Mr. Chairman, for your explanation and the good summary. What I was thinking about was the people piece of it, in terms of, you know, the different things that have happened over the years, particularly the participation by women and so on. And I wondered if that would be something that could be considered or has been considered as we go forward.
Mr. Chairman, Representative Henderson, do I understand your question correctly? Would this mural represent the various facets
Yes.
of the growth of our money? I would hope it would. We would like, you know, nothing more than to be able to share some of the interpretations that might help the selection committee.
Certainly welcome the comments of the sponsor, Mr. Chairman.
Go ahead.
Chairman Nichols, thank you. Representative Henderson, without question, absolutely.
Thank you.
Okay, further questions? Any other public comment? So we will close public comment. Moved on the bill. Any discussion on the bill? So committee, I have a suggestion. But what the first thing I want to do is increase it to $750,000, and I want to pluralize murals, add the Senate, and so that will be 3 members of the Senate, 3 members of the House, and then for the other members, I'm not sure quite how I want that worded, and what I really want to do is meet with Wendy downstairs, because she helped us put together when we did the the working group that selected the artists for the Four Sisters and kind of follow that process and how that it was done. And frankly, it's like, if the Legislative Service Offices means Wendy, then that language is okay, but I just want to run that through as well. And so my suggestion is that we table this for today. I'll sit down with Wendy, rework this thing, and then show it to John, and we'll come back and bring it back. So when we kick this thing out, it'll be signed up and ready to go. And also I want to meet with Senate leadership and folks down there and just kind of do our kumbaya with them and make sure that we're doing the same thing. So any comments and suggestions on that? Representative Larson.
Mr. Chairman, my only suggestion in that process is Representative Conrad brought this bill forward, and I think that he ought to be involved in these processes, the bill moves forward. So the conversation with Wendy and some of the other conversation, it's his bill, it probably should be a part of that.
Okay, any other comments on the committee? So we'll table this for today. I'll get together with you, John, and we'll work in that direction. Okay. Next, we get to do my bill. Yeah, come on up. Anyone that wants to. For this bill, what's the number of it? 264. 269. So committee, this is a bill that that I brought at the request of certain folks that do a lot of work in litigation in the field of workers' compensation. And for 25 years of my law practice, I did a lot of workers' comp cases. And in that process, in the old days, you could retain a legal expert, and then with a medical doctor who's your legal expert, they start at $250 or $400 an hour. And then you have to pay for their testimony, you have to pay for the report, and then if they take a deposition, you have a separate deposition fees. You would submit that at the end of the case to the Office of Administrative Hearings, and it would be reviewed, and they were paid. Recently, the OAH has concluded that they don't have the authority to pay those expert fees, as I understand it. And so we just want to clarify that the employee has the opportunity to retain an expert, and there still will be a review of the expert's fee and the reasonableness of hiring that expert, because you don't want to abuse that position. But that's nothing new. We do that on all of our costs that we submit when you do workers' comp fees and any other thing when you present to a court or the OAH where the fees are at issue. So with that all this basically does is insert language that allows for the employee counsel to retain an expert. So with that, we've got workers' comp folks here. Come on up and talk about the division's position on it and the estimated costs and pros and cons and how you perceive this.
Mr. Chairman.
This is Jason Wolf, by the way.
Hey, Jason, how are you?
Mr. Chairman, I'm doing well, thank you.
Mr. Chairman, just one question is you're explaining that bill is, so is the fees if do the fees come out of the workers' comp fund? Is that how they do? Okay.
Go ahead, Jason.
Yeah, thank you, Mr. Chairman. So yeah, in general, I think we agree with the concept of the bill. Certainly the, doctors and legal professionals should be compensated for their expenses and fees. I would just submit to you for consideration that, as you know, Mr. Chairman, the division has to pay their bills by a fee schedule that is outlined in our rules for workers' compensation. I would submit that we consider that also if the claimant's attorney is retaining an expert witness, that we consider paying those by the fee schedule as well, just for the reason that you said you don't want abuse of that to come to light.
So tell us what that fee schedule is for a physician.
Yeah.
I haven't looked at it for a while.
Yeah, Mr. Chairman, currently it is in, and it's just for your guys' knowledge. It's in.
Jason, can you get a little closer?
Yep. Mr. Chairman, just for your knowledge, it is chapter 9, section 2 of our workers' comp rules. Believe the current fee schedule for those is starts at $750 for the first hour. And then I think for expert testimony, it's $63 for every 15 minutes thereafter.
Which 63 times 4 is 250, right?
Mr. Chairman, yes, testing my math skills.
And so, yeah. And so I would, my biggest question is that enough, depending on, I mean, the division regularly hires experts who work with the division. But the biggest problem I see is if you cannot get one to do it for that amount, then having the ability to then go to the OAH and saying, this is the only guy I can find, and this is what he costs, and have that approved over and above the fee schedule. Does that currently exist?
So Mr. Chairman, yeah, I think a good example of that might be if we have an injured worker who maybe got injured in Wyoming and they have a claim with us, and then they, might move to another state. Sometimes those states are hesitant to take our fee schedule for whatever reason or another. So we usually do in our rules and statute, it does allow for us to do special agreements whereby we can pay by like a usual and customary fee schedule, or we can pay by that state's fee schedule for their workers' comp.
So does that ability apply to an employee's expert?
Mr. Chairman, I don't know that it would. My understanding of the process currently is that unless the claimant's attorney petitions the OAH for
Extraordinary fees or?
yes, that I don't know that those would be allowed.
Well, I think the language needs to be broad enough to allow that. That's my only point. And then so that the OAH can make that determination. And if that language currently does not encompass that, we should address that. So
Mr. Chairman.
go ahead, Representative Stitt.
So Jason, would you agree if this bill is adopted as written, it seems like it would override your fee schedule for experts because it says expenses, expert witness fees and costs reasonably incurred. And I can imagine there being a situation where a reasonable expert witness fee might be $400 an hour for a particular medical expert or $600 even. And then would that create a disconnect between the compensation for experts who are hired by the state versus the compensation for the experts hired by the employee?
Mr. Chairman, Representative Stiff, yes, that's very accurate. And I think that's the agency's concern is that if we are bound to pay our experts by the fee schedule, there should be some checks and balances on the expert fees for the claimant's attorney as well.
Okay, other public comment. Come on up. Jorge's on the line. Okay, great. And when you put George on?
I have done so. He just needs to accept the invitation.
Did you hear that, George? You need to accept the invitation if you're listening. So why we're, oh, there's George. Okay. Go ahead, George.
Mr. Chairman, members of the committee, I appreciate you allowing me to appear this way. I apologize in advance for my voice. I'm recovering from COVID right now, and I assume that you prefer me to be at a distance and present with you over at the Capitol building.
Well, if you go by the testimony today, I think you could probably be on the floor of the House if you wanted to.
I appreciate that, Mr. Chairman. I want to start off explaining to the committee some of the history of workers' compensation and the payment of costs and attorney's fees. See, Wyoming is a unique state in that its workers' compensation system is based entirely upon an amendment to our Constitution. It is a constitutionally based workers' compensation system. The workers' compensation itself is often referred to as a grand bargain, where people who get injured at the job gave up their rights to bring common law lawsuits against their employers in the event of work-related injuries in exchange for certain state legislatively defined benefits. The employers, in turn, received immunity from all lawsuits and agreed to fund the workers' compensation system through premium payments. Most states, they do it through purchases of insurance. In Wyoming, you pay a percentage of your payroll in premiums to the workers' compensation division, which goes into the workers' compensation account. Throughout its history, Wyoming has provided for attorneys to represent injured workers who end up in a dispute with the state over either the compensability of a benefit or the amount of benefits to be paid. Originally, the task of representing the injured worker fell upon the county attorneys. Over time, the hearing authority, which at that time was the judicial system, was given authority to hire to appoint private attorneys to represent injured workers. And at the conclusion of the case, those attorneys would apply to the court for payment of their costs. And that would include payment of their costs and attorney's fees. And that would include any costs incurred during the course of representation. That is the intent of this bill, is to return the legislative intent that injured workers are entitled to free and adequate legal representation to this particular provision of the statute. As indicated recently, and it's only been a couple of years, the OAH has adopted an interpretation saying that we don't have the statutory authority to award costs in the form of medical expenses incurred during the course of the contested case hearings. In fact, they appeal that a decision. One of those decisions was appealed to the state district court. The division lost the appeal, but decided not to appeal the case up to the Wyoming Supreme Court, where we could have gotten a ruling of state-wide application. I passed out a summary of key points. I assume that you received that in your email. If not, please review that. But the essence of this particular proposed amendment is to essentially reassert the legislature's intention that, listen, if you are being opposed by the state AG's office in obtaining your workers' compensation benefits, you also are entitled to have legal representation, and for that legal representation be provided to you free of cost. I would take some issue with some of the statements made on behalf by Mr. Wolf. The division does, in fact, pay doctors more than its fee schedule in non-contested cases. In fact, I know of a couple of cases I was involved in. They paid a doctor named Christopher Brigham under a special fee agreement where he gets basically twice the amount of any other doctor in Wyoming. I would also point out that unlike the division, we don't have the market share on behalf of the injured worker where we can afford to say, okay, doctor, if you would perform these services for us, we will have some return business for you in the terms of 1/6 of the total amount of healthcare dollars actually spent in the state of Wyoming. Now, what you need to understand about workers' compensation is that the cases themselves are largely very medically dependent. Was somebody injured at work? That's usually a medical judgment. Was this work activity the type of activity that can give rise to this nature of this injury? Once again, that's usually a medical judgment. In order to prove those contentions, you need to hire appropriate experts, including medical doctors. Now, some doctors, and this is true of some doctors in the state of Wyoming, most neurosurgeons will not testify for much less than $1,000 per hour. Fortunately, the fee schedule exists in some cases where you can get treating doctors to testify, but where you have to go outside of treating doctors to obtain specialized medical knowledge, you have to find doctors that have special knowledge, and they charge differently. Now, I'd also point out that any fees that are claimed in representation of an injured worker are subject to reasonableness. The attorney is appointed by the hearing authority. They can charge an hourly fee set by the hearing authority, but at the end of the case, the hearing authority decides whether or not the amount of hours claimed is reasonable. And the same thing with any costs that have been incurred. Were those costs reasonably incurred during the course of the case representation? If not, they're not paid. Period. The division, on the other hand, does not have anyone reviewing their costs. They can incur as much in the field of medical expenses that they want. In fact, recently I was involved in a case where they had an expert who provided a report who had asked to see a supplemental single X-ray and charged the division an additional hour worth of time in order to look at an X-ray and write a report of less than 100 pages. That was paid without question.
Mr. Chairman, I think for the most part, we understand how workers' comp works. So, and I think we're, kind of up against some time. I'm just trying to make sure we.
Mr. Chairman, Representative Larson, thank you. I wasn't sure about the level of expertise on the committee with workers' compensation issues, and I apologize if I've been too academic.
Well, it just so happens that George has probably done more workers' compensation cases than any other attorney in the history of Wyoming. So
Appreciate that.
Yeah, he's good at it. But George, yeah, we appreciate your testimony. I think what I'd really like to do is invite you down and speak to as a guest on the floor of the House, but I don't think I can get that done. Well, we'll do our best. But I concur that we need to address a mechanism to addresses the department's concern, but also the concerns that you just expressed. So we'll work in that direction. So any questions for George? I used to also have a law practice with George as well in the olden days. Okay. Any other public comment? Thanks, George.
Thank you, Mr. Chairman. Thank you, members of the committee. I apologize again for taking too much time.
You're all right.
Mr. Chairman, members of the committee,
I just wanted to let everybody know that I think that Representative Larson got up on the wrong side of the bed this morning.
I'll take the full blame.
Go ahead.
Mr. Chairman, members of the committee, my name is Tammy Johnson. I'm the Executive Director for Wyoming State AFL-CIO. We represent workers across the state in all kinds of industries. Just real quickly, the national and the 2020 data that I received, the national average for workers injured on the job is 2.7 per 100 workers a year. In Wyoming, the average is 3.1 workers per 100 workers. So we're pretty high in the scope of how many workers get injured per year in Wyoming. This bill is so important and we stand in support of it because
though many of those workers don't have the resources to access the kinds of expert testimony that Mr. Santini was referring to, and how important those medical experts are in determining the benefits that workers receive when they do finally settle their case. So to have your ability to earn taken away from you because of an injury at work is something that we should all be concerned with. And this bill would provide access for those workers to be able to have their cases fully heard. And so I appreciate the bringers of the bill, and I just want to let you know the workers of Wyoming who I represent, which I assume is all, appreciate it as well. So I'm willing to answer any questions you may have.
Okay, thank you. Any questions? Any other public comment? Welcome, Beth.
Good afternoon, Mr. Chairman. My name is Beth Lance. I'm here today on behalf of the Wyoming Trial Lawyers Association. The Wyoming Trial Lawyers Association does have a section which is devoted to workers' compensation and representation of employees in workers' compensation cases. We have discussed this bill at length with that section of our association. They are all very supportive of this bill. They do feel that this is an issue right now that exists, and that this bill is needed in order to continue proper representation of the employees under this workers' comp system, and to be sure that it's a level playing field. I would stand for any questions.
Questions? Okay, any other public comment? Thank you, Beth. Any other public comment? So, Jason, I have a question. I think as it's currently written, it says reasonable fees. And it's similar to the attorney's fees, and you adopt that by rule and reg, the 150. And so if I would think that as a practical matter, as the bill is currently written, you would still apply your current rules. And if you get bills that exceed that, then you could contest those. And you essentially require the other side to demonstrate the reasonableness of anything over your current fee schedule. Would that be fair?
Mr. Chairman, I think just to clarify, so the division does not set the attorney fees. That's actually spelled out in OAH's rules and regulations.
Right, you're right. But that's an administrative rule that they created.
Correct.
I think the last time it was raised is because I brought it to a contested case in front of the OAH.
Yes,
Mr. Rulemaking.
And Mr. Chairman, I would just add, I think in a general matter, I think it would be, the reasonableness of the fee. I think OAH would probably regard our fee schedule as a reasonable fee. I would just note that it's not in their rules to do so, nor is it in the statute or our rules to do so.
So I would concur with that. And then, so I don't think we need to put specific language to address it in the bill. But any other comments or questions? Okay. We have a motion on the bill.
Move the bill.
Second.
Moved by Representative Larson, seconded by Representative Walters. Any further discussion? Roll call.
Representative Henderson.
Aye.
Representative Larson.
Aye.
Representative Sherwood voted aye via proxy vote. Representative Stith.
Aye.
Representative Walters.
Aye.
Representative Swanitzer.
Aye.
Chairman Nicholas.
Aye. So Beth, if you might want to, I don't know if you've been speaking with any folks in the Senate side. Because this came up late in the game, I wasn't able to get sponsors, but you can maybe help select someone who will present it on the Senate side. Sometimes having my name on a bill like this could be dangerous in the Senate. So. Okay. Okay. All right, next. We've got joint resolutions. Come on back up. Patrick and Dawn. So committee, you may recall that we've had discussions about this. And what this does is it, in order to modify the definition of income, it will require a constitutional change. And that's what this does. So Patrick, once more, going to reacquaint us with the issue about income.
Yes, Mr. Chairman. The big concern that we have is because of the way our asset allocation has changed dramatically. There are many asset classes that do not pay income. They make a total return, a fabulous total return, but they do not produce income. So what happens is that over time, many of the assets that we have will grow and become more valuable and create what is mainly unrealized capital gains in lieu of paying that money out. And private equity is a prime example of that. They will not pay anything out for 10 years, but the value, we could put 100 million investment into them and they could pay, up to 500 million in returns. It could be a wonderful investment, but we don't kick the income out. So the difference is when we're looking at making this spending policy is that if we changed our definition of income, which other states, Utah, Idaho, New Mexico, what have you have done, then you're looking at just like all of us would have in our investment account. You would have $100 in your investment account and you earned a 50% return, you'd have $150. You think, okay, great, I could spend the $50, right? Everyone would say, yeah, but no, not us. We can only spend interest income, dividends, and realized capital gains, which is significantly lower than what it's been historically. So by including the unrealized gains, which right now account as of November was approximately $1.1 billion, then that would allow us to change the way that we fulfill the spending policies.
So explain the 1.1 billion. That's just that's the increase in value over and above the balance, 20, whatever that balance is, in unrealized gains.
Yes, Mr. Chairman. So that 1.1 would equate to the difference between the cost basis of where we purchased the asset versus the market value of the asset as of November's 30th valuation date. And that difference is 1.1 billion. And it's primarily in illiquid assets and equities. Fixed income actually has some more unrealized losses because of the move in interest rates, but that's the net number was 1.12 to be exact.
So I think the question that we need to make sure we address is, does this make it easier to spend the dollars on other than savings or reinvestment for other purposes? So I think that will be the primary attack, I think, on this from the floor. So how would you respond to that?
Mr. Chairman, that is something that I did want to respond to the bill the way it is currently in its current form. And also some of the treasurer's concern is that if we open up, so we're changing the definition of earnings, and then you'll be able to spend the earnings. So without having a inviolate nature or what have you on or spending policy, then that entire 1.1 billion could be spent in 1 year. And that is a concern from the treasurer saying that without having those sideboards, that would be a concern. And from my perspective, from an investment perspective is if you did open that up and then you did spend it, we would then have to reconfigure our asset allocation. And as I mentioned before, those private equity funds or whatever are liquid, you can't sell them. We would then have to go into the secondary market and sell them at a significant loss to be able to bring back down our asset allocation. So if if it was passed in its current form, it would be problematic to manage. And then from the treasurer's perspective, also, it wouldn't provide the protection that he has looked at and wanted.
Questions for Patrick? Go ahead.
Mr. Chairman, so Mr. Fleming, so directing your attention, and we're on House Joint Resolution 6, is that correct?
Yes.
Okay, just so I'm on the same bill. So page 3, line 17 through 20, which I think gets to the heart of what earnings are. Provides right now, earnings which may include both realized and unrealized gains as prescribed by the legislature shall be deposited or credited by the state treasurer in a separate earnings fund on not less than an annual basis. So my question is, what's your understanding of how the may that shows up in line 17 related to the shall in line 18? And here's what I mean. If so, let's imagine your cost basis is 100. But now the market value is 200. Okay. But you haven't sold anything. So you've got unrealized gains. That's now going to, all of that, on your cost basis, you could, if your cost basis is 100, now the market is 200, you can say that a whole additional 100 is earnings. You could say that. Does the way this is worded, does the treasurer then have discretion to decide how much of that 100 gets deposited in the separate earnings fund? That is it possible for the treasurer to say, because earnings may include both realized and unrealized gains, does that give the discretion to the treasurer to say, well, you know, the earnings may include that, but I'm not going to count all of them. I'll just count $60 worth. And so instead of depositing $100 into this earning fund, I'll just deposit 60. I'm just trying to get a handle
Mr. Chairman,
on
Representative,
discretion.
I'm going to pass this over to Katie, but the wording of this is problematic because when you think of that $100 in unrealized gains, they're not hard dollars. They cannot be deposited. It changes every day when market moves. So it's not a deposit per se. It's just an amount that could be spent. It's when the other states who do this, they just look at it and it's really just a dollar amount that they're looking at, but those funds are not deposited in a separate account. So with that, I'll pass it over to Katie for the accounting perspective of how that would be problematic.
So, Mr. Chairman, follow up.
Go ahead.
So would it be cleaner to just say on line 17, earnings may include both realized and unrealized gains as prescribed by the legislature, semicolon, and delete the rest of it, and then delete Romanet 2 in its entirety, and then keep the Romanet 3 on the following page and just call it done. Is that cleaner?
Mr. Chairman, I'm Katie. I'm the Chief Financial Officer for the State Treasurer's Office. Yes, Representative Stith, that would be ideal. You cannot deposit or credit something that doesn't exist in accounting world. It has to be realized for us to distribute it. And so if it's not there, we can't do that. So yes, it would be ideal to delete that piece.
Mr. Chairman, one other comment. I just want to relay the treasurer's thoughts in that if this bill if it passed, you wouldn't be able to do the constitutional amendment until the next session in 24. And would it be better to do a study, an interim study during that period instead of passing something that would not take effect till later on?
So it would come up in the next general election, which would be a year and a half, right, essentially, year and 8 months. But the question is, what is an interim study going to do more than we already know now, other than perhaps educate more legislators about it? An interim study is, well, our cap fin can continue to study. This was a cap fin project already. So. Next session is a budgetary session. So it'll take 2/3 majority just to get it to the floor. So we would actually have a better chance of getting it passed if we have the proper language this year than probably during a budget session. But we're a week and a half away from having the, 2 weeks away from crossover. So if it's going to come out of this body on the House side, we've got to do it in the next week. It's one way or the other. So there's no doubt there's a time crunch on it. Plus, this requires 2/3 majority, and the only way we're going to get 2/3 majority is if, I believe, is if the treasurer supports it. So, thus the conundrum. And frankly, the chief executive probably needs to support it as well. So we'll have to work on that, those two issues while we tinker with the language.
Mr. Chairman,
Go ahead.
thank you. While you're tinkering, we're unclear what the purpose of the earnings fund would be, given
So the earnings fund came about as part of our discussions through the Cap Fin. Because and one of the reasons for the fund was it would not be inviolate. So those would be the funds that you could invest more freely. And as I recall, Patrick, we were saying, well, if we can't, depending on, particularly on covering losses and those type of issues, we wouldn't have to do it. In the same manner as we would have to for the inviolate portion of the permanent funds. And so at one point we discussed that and thinking, well, maybe we need to separate them out in order to so we don't essentially, it would always self-regenerate theoretically, and you wouldn't have to then worry about having these excess dollars outside of the quote unquote inviolate amounts. And you can do it by creating a fund, or you can just do it by designation. It's kind of like you said, I think New Mexico or Utah does. It's all together. They just keep a running tally of the numbers. So I think it's trying to do the same, that concept. And that's how that language got in here during the interim. Because this is just the interim bill that we were circulating in Cap Fin. And I think that's how that number, that's how this separate fund would evolve. Go ahead.
Thank you, Mr. Chairman. A question to Patrick's comment earlier about additional sideboards so that we don't end up spending everything and causing more headache for ourselves than we already have. Are you suggesting putting a spending policy in the Constitution? And if so, would you be concerned that if the markets changed, it takes so long to move that, to get through the constitutional process, that the ability to change that spending policy up or down becomes problematic? So just expand on what you were thinking, sideboards wise, spending policy, all that.
Mr. Chairman, Representative, I prefer not to comment on the amount or what you should do or what have you. I'm just saying that it would be problematic for us if you left it the way it is from an investment perspective, but I can tell you what other people do. So let's just say we're at 5%. So let's just use that just because that's where we are right now with the common school. If you kept that number, New Mexico, they actually come in and do a constitutional amendment to change that spending policy. And in fact, they just had an amendment. I don't know if it passed or not, but they just had an amendment to increase their policy to a higher level because of the Permian Basin and the monies that they were receiving. Another way that has been done is to then leave the definition of what that policy is up to the legislature. So right now we have a 5% spend on a 5-year rolling average. As you know, that the 5-year rolling average changes over time. So if you need more money, the legislature would then be able to say, we're going to change the wording of that 5% spend to a 1 year, the last year's number. And so that is how they then are able to change how much money that they are able to spend over that period. So there's different ways that people have done it. But without having something that would protect us, that would be problematic if it was spent from the investment perspective.
And that's another issue that we discussed in CAPFIN. And in fact, particularly the Senate side wanted to make spending policies constitutional. And our response was, well, how do we do that? Because you can't pick a number because you're always going to be at risk of high or low inflation. And so if we did do something in the Constitution, it would have to create some type of a floating variable concept. And so that issue kind of bogged down because then where you peg it and between what and what. So, is that your recollection, Mr. Co-Chair? I'm talking to you, Lloyd.
It is. It is that they wanted to do that. And my question, Mr. Chairman, is, or I guess my concern on that a little bit, and I guess it's from a perspective, it's the strength and weakness, and that's the ability to change in a constitutional amendment. It's not an easy trick. And so if we really anticipate that a change may at some point happen within the next 20 years, I think there's some real challenges to that. That may not seem very far off, but it's not very far away. If we don't think, if we don't think a change is going to happen in the next 100 years, go ahead. It's kind of my opinion. And I've run a constitutional amendment just trying to get the indebtedness of municipalities changed 2%. And it's, it's the undervoters that kill it. I mean, constitutional amendments are challenging. And so as much as I appreciate sideboards, is the Constitution where we want to have them is kind of my question. And if the legislature is, an unrestrained group of spendaholics, then maybe we don't. I don't know, but if that's the perception, I'm not quite sure. But I think there's some challenges, Mr. Chairman, having that actual this percentage, the numbers in the Constitution really. If we anticipate there's going to be a change, getting this done is not going to be an easy thing. Just having gone through that a couple of times and seeing the constitutional amendments that we had in the last election, one was successful. The one that we thought would be the easiest, letting the judges sit for another 3 or 4 years. So, I don't know that was more of a conversation than a question, but I'm certainly open for perspective if you guys have a feel of how that looks.
Mr. Chairman, Representative Larson, just quick comment on timing. When you're saying 100 years, 10 years or whatever, that's really hand in hand with what we're talking about 89. So you would at least have a 5-year runway that we know for sure with the reserve account policy that we have as well. So when looking at that, that it will protect you for a certain amount of time. It's not going to be like a yearly or a 3-year scenario where you'd have to have major concerns about whether or not you could reach that amount. But 10, 20 years, I have no idea.
Mr. Chairman, Representative Larson, I totally agree. I understand the concern. I think when the treasurer was proposing it, he was proposing it as a maximum so that the legislature had ability to modify that spending policy up to a certain amount, depending on how expenditures were required to be made by the legislature.
Can you give me an example?
Well, and part of our discussions in CAPFIN was that you can only do it gradually. So if it's a 5, you can raise it to 6, but you can't raise it to 9. And then you come back the following year. And so you just slow the process down. Is one of the concepts that I think that he brought up. But No, it's a complicated thing. It just is. So.
We have an income account currently for the Common School Permanent Land Fund. So is this would the intention be to replace that, or is it the same concept?
Same concept.
Okay.
Could we just, Mr. Chairman, could we just put it in the income account?
Well, if we take out the separate fund, that's where it would go. I think, just anyway.
Yes.
So committee, I think we've got the same problem with this. And so I think that maybe Representative Stith and I can work with Patrick and the treasurer and see if we can come up with some language that will make this thing work.
I'd sure hate to miss this opportunity.
They have to have 2/3 vote. You have to have 2/3 to introduce it. The 2/3 to pass it. So it's really the 2/3 this year, next year really doesn't matter. As
Yeah, I don't disagree with that. If we can't come up with something that we can get support from Kurt and frankly from the governor, then we're spinning our wheels anyway. So that'll be one of our weekend projects. Especially if you can't go to back home. Okay. Appreciate your testimony. So we'll table this as well, both of them.
Okay.
And that clears the debt. So what are the bills that we received today?